Thank you so much. I appreciate the introduction and for you all being here and listening. Just to repeat, my name is Carr Peterson, and I'm here from the Department of Political Science, and I'll be presenting some research that has to do with the private finances of members of the federal government, the bureaucracy in particular, and this is both research from my dissertation and from what I'm presenting when I'm on the job market this year. So just to serve as an introduction at the broadest level possible, what motivated my consideration of the project is the interplay between the notions of bureaucratic discretion on the one hand and bureaucratic neutrality on the other. So we vest an enormous amount of power in administrators, bureaucrats, members of the federal administrative branch, sort of fourth head of government, and the amount of discretion that we give bureaucrats in policymaking is really driven by this idea that bureaucrats are going to exhibit a degree of neutrality in their professional, in their political, in their administrative decision-making. So this idea of bureaucratic neutrality is informed by fundamental notions of democratic fairness in terms of why these people are in the positions that they're in. So the question really underlying a lot of the research is, what are the sorts of ways that bureaucrats might be non-neutral that make us normatively uncomfortable? Because there are ways that bureaucrats aren't neutral that are also related to and informed by the reasons that bureaucrats have the positions that they do. So a lot of these people are technocrats, they're trained, they have PhDs in substantive fields as wide as energy policy to financial policy, and the reason that they are vested with this enormous amount of discretion is that we trust them to have a certain informed opinion in their decision making that doesn't make us have any kind of normative misgivings. But there are types of administrative or bureaucratic non-neutrality that really trigger a lot of notions of things that we think are really unfair. And the sort that I'm considering right now in my dissertation and in elsewhere, not only with bureaucrats but with other public officials in general, is this possibility that professional and political decision-making is driven by public officials' own private financial interests. And this is something that makes us normatively uncomfortable for, I think, reasons that are relatively obvious and go back all the way back to kind of traditional notions of graft and corruption. But what makes this particularly interesting from a scholarly perspective and particularly troubling from a normative perspective is the possibility that the professional decision-making by bureaucrats that's supposed to be public policy, broadly construed, broadly implemented, is made in association with the personal investments or private finances of members of the federal government or other levels of government potentially as well. So to introduce a little and give you a roadmap, I'll discuss the motivation for the project and what sort of led me here, both as a scholar and a researcher and a student. And I'll lay out a little bit both of my theory regarding how the private finances of members of the government might be associated with their decisions, as well as a little bit of the existing research, what little there is in some circumstances, and then discuss my case selection of the National Labor Relations Board, the data, the kind of massive data collection project that was involved, the methods that I use, and the results that I find, and then offer up a few conclusions and where the research is really going forward, both with this project and with other related and similar projects that consider, in a broad sense, this interplay between public and private dynamics in terms of federal and other sorts of policy making in the American government. So it's one that really taps into the institutional variety in the American institutional landscape, and it gives us a lot of leverage on questions about types of decision making that everyone thinks are sort of obvious and that are really motivated by some of our most pessimistic conceptions of the way public officials might be making choices. But what I'm hoping to do is to offer a systematic and a really convincing set of empirical leverages that give us a little bit better idea about the construct of that kind of decision making and the sorts of constraints that exist on public officials in terms of ethics rules and ethical norms that they're subject to. So the motivation for this project, it might seem obvious now, and believe it or not, I started studying the personal finances of public officials well before there was such a thing as the Trump administration. Really through no credit of my own, I came to this project a couple of years ago, and now I really can't get in a cab anywhere or an Uber or a Lyft without somebody asking me, what do I think about Trump? Try as I might to resist the urge to talk about it, I really can't stop myself. And I never really thought I would see the day where you can open up really any newspaper or online blog about politics and find something about the personal finances of federal administrators. It is a depressingly relevant topic, but believe it or not, also, it didn't begin with the Trump administration like so many things didn't either. The story that there are certain implications for what holdings federal administrators have goes back not just to Obama, but to presidents before. But I mean, there were front-page news stories when President Obama nominated Penny Pritzker, Hyatt Hotels heiress, to be head of the Department of Commerce. And this notion that extremely well-off people are nominated to posts in the federal government and then are given really broad discretion to make broadly applied public policy is one that people have been uncomfortable with, and the implications of that are ones that we don't really know a lot about in a systematic sense yet. So with this landscape behind us, and now given the really high salience of the issue because of the Trump administration and the record number of billionaires in the cabinet, I wanted to sort of hone the focus on what do we think the possibilities for the conditions under which bureaucrats and administrators are making public decisions or decisions with public consequences based on their own private finances are. So in this project, I'm broadly motivated by this research question of how do bureaucrats' personal finances impact their decision making? And I'll get back a little bit more specifically to what the actual research question for the paper discussed and this empirical chapter of the dissertation are later. But before that, I'll give you kind of the 50,000-foot view of the existing research on the topic. So going all the way back to sort of continental European theorists of bureaucracy and administration, we have this normative idea of bureaucratic neutrality that's informed by the idea that specialization justifies discretion, and that bureaucrats are going to be making decisions that are more professional than members of what we in sort of the American politics crowd would think of as the elected branches of government. So you have separation of powers and you have specialization of functions across them. And then within the administrative branch, which is really charged with the task of policy implementation, this notion that bureaucrats specialize is the one that's really driving the engine that allows us to be, at least in a theoretical sense, comfortable with vesting them with a certain amount of discretion. Now, in the past 30 or 40 years, there have been a lot of scholars having to do with theories of institutional control, of interinstitutional control, political overhead control by other branches of government over the bureaucracy, whether it's the courts, whether it's Congress, whether it's some kind of hierarchical control within the administrative branch of government. And the notion is that there are other actors that are trying to use the bureaucracy to further their own political or policy ends. In keeping with that, there are relatively new strands of research having to do with how the personal finances of members of different branches of government, in particular so far some work that Christian and I have done here at USC, has to do with legislators both at the federal and the state level, and how their policy choices might be driven by their own personal financial interests. And what I'm choosing to do in the dissertation is to expand this consideration to members of the federal bureaucracy, which is a group that I think by and large, even taking for granted some of our more pessimistic notions about their behavior, we think that they should at least be a little bit more detached in terms of political factors driving their decision making than we are about members of the legislative branch or the president, him or herself. So my theory contends that bureaucrats themselves, like any other rational economic actor, will seek to maximize their personal financial well-being subject to sorts of constraints. In a mechanical sense, this means that bureaucrats are doing better off when their investments are worth more and worse off when their investments are worth less. So in terms of the operationalization of the theory and the tests that I'll perform later on, the idea is that if bureaucrats themselves are even partially motivated by their own personal financial interests, we'll see that in their decision making, particularly to the degree that administrative choices are associated with economic outcomes. So if members of the federal bureaucracy are making policy choices that have economic implications, whether it has to do with, as in the case that I'll talk about later, industrial relations disputes between labor and management across different firms, whether it has to do with regulation, having to do with consumer product safety, with highway safety, with different sorts of securities transactions or trade laws, to the extent that those decisions have economic consequences, we should be seeing in the decision-making by members of the bureaucracy something associated with those bureaucrats' own personal finances, which are subject to mandatory disclosure rules. So we have the evidence there. All we really needed in terms of pushing this one step further and in applying the theory to the facts is a well-chosen case and a well-ordered case that has clear enough economic implications to test whether or not bureaucrats might be driven by the sorts of consideration that are implied by my theory. So to turn back to this, we had already the broad research question of what is the association between bureaucrats' personal finances and their administrative choices in their role as federal administrators. And more specifically, I chose to analyze decision-making by members of the National Labor Relations Board and to ask, first, whether the personal financial interests of members of the NLRB are associated with their decision-making in industrial relations disputes. And second, if we do see that, what is the actual mechanism that we see in terms of the decision and what sort of association is there? Because members of the board are, like any other member of the federal government that's either serving in a regulatory or an adjudicatory capacity, are prohibited from making decisions that directly implicate their own finances. So just like a federal judge, there have been federal judges in the Sixth Circuit Court of Appeals that were removed from the bench because they decided a case where one of the litigants was a firm that they owned stock in. Members of the federal government, at least in expectation, are subject to the same sort of ethical constraint that would prevent them from hearing a dispute. The NLRB is an adjudicative body hearing disputes between two disputants, and if a member were to own stock directly in a firm, they would be, at least by the first blush law of ethics, prohibited from hearing it. But what I'll consider when we turn to the case selection and the kind of way that I empirically test the theory, there are ways that bureaucrats and administrators' personal finances and the value of their personal investments can be implicated other than if they own equities or some sort of stock or other sorts of equities in a firm that's directly involved in a dispute. Sure.
So I like that you have a start hypothesis here, but it's obviously unrealistic in the sense that they care about many other things other than their financial interest that may be low down the list of things they care about. Can you just say a little bit about how you're thinking about that? I mean, certainly I think of it as a factor, but you're sort of proceeding as if there's no other things here. And I know you don't think that, but tell me how you're thinking about it.
Yeah, so I guess the only way that I've dealt with it so far is tacking this phrase subject to constraints onto everything I talk about in the theory, right? And I think that there's a lot to unpack in that little bit that I do in the empirical test control for. But I think that you're right in that I'm not offering a theory that's intended to supplant existing theories of administrative behavior. And I think that the theory here, it may be something that's operating around the margins. It may be that you have a Democrat on the NLRB who's been a labor attorney his or her whole life and who has certain commitments to making sure that collective bargaining rights are enshrined and are protected by the law and are protected by the board. And that might be a preponderating concern when they're actually making a decision. But it may be that if you go down on the list of things and you have a whole host of similarly situated disputants who are all labor litigants, who are all union, people trying to organize, people trying to protect their collective bargaining rights. And it may be that once you get down the list of constraints and you've already considered for who's the appointing president, what's the sort of internal board ideological factor bearing on that, what are the legal factors and the sort of administrative factors that bring that case before the board. It may be that there are certain amounts of, for instance, there are certain amounts of deference afforded to administrative law judges, which are the NLRB equivalent, the kind of administrative equivalent of a trial court judge. And once you get sort of through this list of political and ideological and administrative factors, this may be operating around the margins there, but it doesn't necessarily mean that it's a factor that can be discounted in terms of theorizing about it. But I think that it is important to take into consideration that it's not necessarily going to be this open and shut case of somebody who's a cartoon villain, right? Who's just sitting there before the board and looking at their stock portfolio while the disputants are before them and they're trying to decide which of these is going to advance their personal finances more or less. But I think that, yeah, it's something that I do control for in an empirical sense, but in terms of framing the theory, it is important to note that this isn't offering an alternative explanation in terms of administrative behavior, whether before the NLRB or otherwise. I think the NLRB in particular, as a test case, as I'll talk about in a second, is a good choice in terms of robustness of checking the theory, because most of the scholarship, both in sort of the legal world and the academic world in political science and public policy, suggests that members of the NLRB are particularly well suited in terms of professionalization, and the sorts of decisions that they make are well associated with sort of predictable political factors in terms of Democrats preferring labor and Republicans preferring management, that it's a test case where if we're going to see the sort of operation of the implications of my theory, that if we're seeing it there, we're likely going to be able to see it elsewhere if we are able to devise an appropriate test for it.
So I guess the question, thinking, listening to your answer and my question, I guess the issue is that I have no doubt that people's decisions might be covered at some point by their financial interests. I guess the question is, if we're trying to understand bureaucratic behavior and trying to understand when are they non-neutral? I guess what we want to know is how important is this particular factor? Not just like, oh, if I control for every other 1,000 other things, if everything's equal, then the financial interests matter. Well, that might happen in 1 or 1 million cases. What we really want to know is over or the suite of decisions they make, how much are financial factors important and control the others? And maybe you're going to speak to that in the empirical stuff, but it's not just a matter of controlling away and taking out all the other stuff. We got to care about how important is that other stuff too. We don't want to just control it and control it away.
Yeah, I understand what you mean. So I will get to it, I think, in a sense. I don't know if it'll address directly what your concern is, but I think that it is important to differentiate those two approaches. On the one hand, just are we controlling for it and still finding some sort of marginal effect, but whose magnitude is not really going to be substantively important. I think that when you look at the distribution of the data, there is pretty persuasive evidence that when you hold, at least in terms of, I offer predicted probabilities later in the paper or in the talk, and I think that there's a pretty sufficient demonstration that if you go from a really low level of investment in an industry, which is kind of the setup here, is whether or not they're invested in a given economic sector, to a really high level of investment, a high but non-outlier level of investment in that same industry, you see the sort of behavioral implications of their financial interests as the theory would suggest. I don't have data here that actually compare the relative magnitude of the pre-existing political factors that exist in terms of NLRB scholarship in particular, which is what I was most concerned with controlling for here, such as administrative deference on the one hand and political factors in terms of the party appointing president on the other. But I think that I've done my best to sort of present the relative magnitude, at least moving across values of what will become the independent variable of interest having to do with the finances of the members. But I think that it is a good idea going forward to sort of supplement the talk with what is the relative magnitude of being a Republican or a Democrat in terms of a pro-management vote, alongside what is the relative importance of the distribution of the own members' assets when they're making a choice. So if that's more or less. Right, so the labor board is something that is not really in the national news a lot, unlike the Trump administration's finances, but it's something that in terms of administratively constructing the contours of industrial relations policies been really important in the federal government for the past 80 years now. So like many members of the administrative branch in terms of independent agencies, this is an independent agency that is a function of statutory creation in the 1930s. So we saw this in a flurry of other legislation that was formative in terms of the beginnings of the modern administrative state. And Franklin Roosevelt signed legislation with Secretary of Labor Francis Perkins behind him, the National Labor Relations Act, also called the Wagner Act in 1935, which created the National Labor Relations Board in order to bring labor peace after at least a half century, if not more, of industrial disputes having to do with a lot of really fervent disagreement over the rights of workers to collectively bargain, really since the beginnings of the industrial age in America. So from the very beginning, it was a controversial proposal and controversial legislation. The Wagner Act was challenged in court and upheld by the Supreme Court, which is another example of mechanisms of interinstitutional control and how they might or might not impact the board and members thereon. And ever since the beginning, not only has the Wagner Act been subject to legal challenges and to attempts of political control by other members that are actually formally in the government, it's been disliked by both labor and management with allegations that it's biased toward one or the other. So with some political cartoons here, you can see you have a hawk handler or something, and you have unions that are tending to the NLRB as it shreds a plane from Boeing because they were inappropriately intervening in the sort of corporate actions there, operational culture. And then on the other hand, you have a cartoon showing the NLRB as big business, stamping out union rights. It says class war, what class war? So something that there's been a lot of disagreement about, which I think is in some sense at least anecdotally related to the fact that the board is maybe more or less doing its job. You have one side is unhappy, the other side is unhappy. It seems to be evidence of a compromise. So in terms of a case selection, it gives us pretty persuasive evidence that the board is one that, if we're seeing the sorts of operation that are consequences of my theory in terms of the empirical evidence, we can be relatively confident that we would be able to find it in other sorts of regulatory and adjudicative atmospheres as well. So like I said, the NLRB is an independent agency in the executive branch. It adjudicates and regulates private sector labor relations. The overwhelming majority of its action has to do with adjudication, not regulation. It does issue rules every now and then, but it's the overwhelming majority of the work has to do with adjudicating disputes. They're processed up through administrative law judges, as I was discussing a moment ago. So if a group of workers is trying to form a union and the employer won't let them, they can file a petition with the local NLRB office, and it's then either heard by an NLRB regional director or an ALJ, and then if either party is unhappy with that decision, it's appealed up to a 3-member panel of the 5-member board. So what I'm doing here is applying my theory of how bureaucrats' personal financial interests might affect their administrative decision making by considering board members' votes in these disputes that go all the way up to the board from an initial trial. So the decisions, I think pretty clearly, there can be substantial costs applied to management if they're resisting organization in terms of forming a union, protecting union rights, allowing unions to organize and actually operate on the business premises, on the facility. So the economic implications are clear, which I discussed already as a necessary condition for the operation of the theory, and it's a difficult test case for the reasons that I've discussed, having to do with this established track record of professionalization on the board itself. So to offer this as sort of a what I would call a straw woman argument, you have the Secretary of Labor, Frances Perkins, who was there present at the signing of the NLRA in 1935, and she contended that the groove of the NLRB's activity is so well defined that we can actually ignore all the propaganda members of the board and devote their entire time to quiet, unimpassioned performance of the judicial process. So, this is an aspirational quotation from the former Secretary of Labor, I would say, and what it does is it really drives us to consider when and under what conditions bureaucrats are making decisions that favor their private financial interests, in contrast to the expectations of the woman who is actually in charge of administering the department of the cabinet that's most closely related in a substantive sense to the operation of the NLRB, even though it does sit outside the Department of Labor in a formal sense. So the hypothesis that flows as an observable implication from the theory of personal financial interests and bureaucratic decision-making that I offered earlier is presented here in terms that are more specific to the types of disputes that occur before the labor board. So I call it the competitor punishment hypothesis because it suggests that the greater an NLRB member's personal financial interests in a certain economic sector, the less likely that member will rule in favor of disputants, management disputants from that economic sector in these disputes before the NLRB itself. So the notion here is that if there's a dispute between Ford and a group of employees at Ford, and it gets all the way up in terms of appeals, all the way to the full labor board, that a member of the board is more likely to vote against the management disputant, which is an automotive company, the greater their own personal investments in members operating in the same sector. So the notion is that the economic implications of this are going to be negative if there's a pro-labor vote, and that the extent to which the member is invested in other car companies is going to drive them to go against Ford before the board because the drop in stock price that would occur as an economic cost to Ford of the full assertion of union rights is going to be good for the other members of that sector. So the alternative hypothesis to this is informed by a little bit different notion, but one that I sort of relegate to secondary status, because I think that it doesn't really make sense when you consider the way that precedent operates before the board and whether or not it has clear, there aren't really sector-specific precedents set by the labor board. So what I call the alternative, the precedent creation hypothesis, has the expectation going the other way, which is that the greater the extent to which a member is invested in an economic sector, the greater the likelihood that they'll vote in favor of disputants from that sector too. So this is the idea that a rising tide should lift all boats, and that if a member is invested a lot in Ford or GM, if there's another car company, the board member will vote to uphold the management rights to either sort of squelch organization or limit organization on the premises, because what's good for one member of the sector should be good for the other. Now I think that this one, the reason that it is relegated to secondary status is because it doesn't really make sense in terms of the way the operation of the NLRA as passed in the 30s and amended again in the 40s, because the way that the board is making disputes there, most of the regulation and the adjudication doesn't have anything to do with specific operating characteristics of members of one sector or another.
So are members not allowed to vote on disputes with companies that they actually hold?
Right, if they actually own stock in the company, they have to recuse themselves.
So when you write the member's personal financial interest in a certain economic sector, that by construction is going to be firms not involved
other
in
than
the dispute.
exactly, right. And there are rare but present instances of recusal on the NLRB. It's more or less, I'd say, at the same rate as a federal court.
So the hypotheses are about the same variable, right?
Right.
It's just different signs, right?
Right.
So you win either way.
Well, I guess to the extent that they're presented equally, then maybe.
Well, this is your hypothesis, and that's the alternative, isn't it? The second one?
Right. Yeah, so the theorizing, the argumentation, I think when more developed, is pointing toward the idea of competitor punishment. But in terms of one or the other being statistically associated. Yeah, as long as there's not a null effect or a zero effect, it would be presented that way. Another unique characteristic that allows us at least a better try at causal leverage in terms of the NLRB itself is that we have demonstrated evidence both in existing scholarship and in the work here that disputes are heard not by the full 5-member board itself, but by 3-member panels of the board. And so in some ways this can proxy for randomization of private finances on the board and allow us more causal leverage because it's a natural field experiment on bureaucrats. So you can see here a balance check of the percentage of the full board over the time period studies that's either Democrat or female is 60 and 20% respectively, and the percentage of members actually assigned a dispute, so the percentage of each one across the whole sample is 67% Democrat and a little over 21% female, which are both statistically indistinguishable from zero. So we can be relatively certain that the assignment to dispute mechanism in the NLRB is random. So it's sort of a neat feature that most institutions in the federal bureaucracy don't actually share. And what this allowed me to do is to construct a reasonably reliable test to think about how private finances might be motivating administrative decision making there. So I created an original data set by reading all the cases. It was about a little under 800 in the set that I read of cases before the NLRB from 2011 to 2014, including both the outcome of the case and the disposition at the administrative law judge level below, and then looked through the NLRB members' personal finances, which they are mandated to disclose to the federal government, the Executive Branch Office of Government Ethics. And what this involved was threatening a Freedom of Information Act request to the NLRB after months of them sort of dragging their feet and not giving me the forms for people that had been on the board a long time before. And then after dealing with them enough times and finally getting I guess the most powerful ethics official in the board on the phone, they overnighted me a 9-pound box full of disclosure forms, which is maybe evidence of waste in the federal government for one, but was good for my purposes because now I have the forms available in hard copy, and these forms are destroyed 5 years after a member of government leaves their office. So unfortunately, I can't extend back farther in time past 2011, but what this gives me in terms of information is a set of what each member owns. So this is assets going vertically, United Bank of Scotland, account, deposit account, Apple stock, Boeing stock, Coach stock, Deere & Company stock, and then valuation bins going from 0 to 1,000, 1,000 to 15,000, 15,000 to 50,000, and so on up. So we get ranges of valuation, but we can still tell in terms of relative distribution what these people own. And I was able to go through and code the industry of the different sorts of equity assets that all the board members own, and then compare that with the extent to which the board members are either systematically favoring or disfavoring management disputants in the actual disputes before the board.
This is self-reported information?
And most of it, I get the impression, and sometimes they'll even append a letter like from their accountant showing that it's pretty clearly not them personally doing it, at least not at this stage. If you go back to some of the older forms, like in the 90s when there were relatively unprofessionalized members in Congress, you could see that they're handwriting their own forms. But now it's pretty much all done. It looks like there's like a firm that does all of them. They're so systematized. But
what about money in funds? Mutual funds.
So they report the mutual funds just with the title of the fund itself. And a lot of them are things that can't be unpacked in terms of the actual.
You have to unpack those or anything?
No.
Do you know what percentage of the wealth is in those unpackable things versus these specific ones?
So it varies from one member to another. I would say that the median levels of wealth, both total percentage mutual funds and raw amounts of mutual funds and stocks, is way lower among members of the labor board than among members of Congress, for instance. It's about on par with non-Supreme Court federal judges. I think that in terms of central tendency, the average amount is probably anywhere between 40 and 60% in mutual funds. And it varies a little from one to the other, but that's probably the average. To the extent that mutual funds are sector specific, I was able to code those by sector, but there weren't very many. So they're energy funds, they're kind of bank funds, but most of them are just these sort of like S&P 500, some kind of index fund. So what I did now that I had all this information about what the members of the labor board own was I estimate a regression where the dependent variable is the vote in an individual dispute at the member layer. The unit of analysis is the member case or member dispute. And this is coded 0 for a pro-labor vote and 1 for a pro-management vote. The independent variable to test the hypothesis is the member's level of personal financial investment in the outcome. So this is the dollar value of the member's personal investment in the economic sector that the management disputant operates in. And other independent variables that I control for, despite the quasi-experimental research design, are the member's party, coded 0 for Democrats, 1 for Republicans. All the board members at one time are appointed by the same president, but there's an institutional norm on the board that there should be no more than a 3-to-2 advantage in favor of the party of the president at any given time. So right now there would be 3 Republicans, 2 Democrats. Through most of the Obama administration, it was flipped the other way. So it can never be like a 5-to-0 vote. So the consequence of that is that even President Obama was appointing Republican, even if nominally, members of the board, and vice versa. And then I also
financial interest is in dollars, not in percentage of wealth.
I have it in dollars, and then I also estimate an additional regression with percentage with the same results.
So each observation then it's like the vote of all 5 members of the board, or each observation?
3 at a time, but yeah. So yeah, so the unit of analysis is member vote.
Member vote. Oh, the unit of analysis is a member vote.
Is member, yeah.
Okay.
Member vote. Yeah, so this is not outcome per case, because for most of the, I mean, I think even if you look at the kind of general distribution, and one of the knocks in terms of criticisms of the board itself, not the scholarly knock, but normative knock, is that it has a pro-labor bias. So I think even if you hold everything else at its mean, the overall average of pro-labor votes is somewhere between 70 and 80% when there's a Democrat administration that's been in control of the appointments for a long time.
Is it hard to code the outcome?
Never. Not in the cases, in particular the 85% or so cases that are unfair labor practice disputes. So this is when a management or a company is trying to prevent a union from organizing. There are a certain number of disputes that have to do with union representation. And so, you know, unions have elections in their companies, and there can be disputes in terms of the operation or the administration of the election. But usually what happens in those cases is that it's management challenging the election on behalf of an alternative union. So in those cases, it was coded as pro-management if whichever union the management was backing, and that was usually pretty obvious from the case. But I also exclude all the union representation elections and re-estimate the regression that way, and the results are also the same. But the overwhelming majority of the work is these unfair labor practice disputes. Yeah.
So personal financial interest, that's in dollars of the sector?
It's in dollars in the sector in the table that I'll show in a second, and the results are the same for dollar values in the sector as a percentage of the total wealth, which itself is also a control variable. So then based on the notion that it's possible that some sort of pro or anti-management tendency is also associated with the degree to which a member is just wealthier or less wealthy, I control for the total wealth as well. And then I also control for the initial disposition at the level of the administrative law judge. And that's coded 0 if the ALJ was pro-labor and 1 if the ALJ was pro-management, because there's also this demonstrated tendency that just like an appeals court judge would defer to the judgment of the trial court below, to a certain extent that they're considering a rehearing of factual findings, that members of the labor board will also defer to the initial disposition of the ALJ, barring some sort of, you know, somewhat exceptional, but not, you know, absent circumstance.
Is the level of deference like the same for both of these kinds of cases, like, or for all?
Between the unfair labor practice and the representation? Yeah. You know, actually, I don't know off the top of my head. My suspicion is that it is. And then, just in the interest of thoroughness, the representation disputes are the ones that are heard by regional directors, and the unfair labor practice disputes are the ones that are heard by the ALJs at the trial court level, but it's the same sort of proceedings in terms of administrative procedure. And I would guess that the level of deference is probably the same, but it's worth looking into.
Jordan, for your DV, it's the particular member's vote, not the
Right.
overall outcome.
Right.
Do you think there's any sort of game theory going on? Because it's obviously a small group. You know, it's a drawn sample of
Right.
an already small group. So you're like, okay, well this time I'm going to vote yes, but really I could vote no. And
I think that it's,
is there any way to structure, you know, do either another estimation or structure your DV in a 2-stage or something?
Yeah, I think it's possible, particularly because dissents, and they say this pretty much every time they're confirming one of these people before the Senate. You know, Elizabeth Warren is kind of railing at them about one thing or the other, and they say, well, you know, dissents on the board are rare altogether. And I think the sort of downside of that, and it's in a lot of ways related to your question, is that there were few enough dissents that there wasn't even really enough to analyze. Not that the dissents themselves are particularly robust in their operation. you know, in terms of being cited in. It's rare but possible that in future cases there could be members of the labor board, because they have their own internally operating board precedent, right? There are occasionally cases where the membership flips from a majority of one party to another, and it might be that there are signals in old dissents before the board of legal argumentation that may be adopted in terms of when there's a party switch or something. But I don't see it as something necessarily is interfering with the operation of the theories as presented here.
Less so than like the Supreme Court.
Yeah, so you don't get the same sort of group characteristics, I don't think. It might just be because, I mean, panel effects may be there, but it's only 3 members out of 5. It's not necessarily, I don't think, the same. The implications and the procedural structure are, I think, sufficiently different from a big court. But I think that it is something that if, to the extent that I can get data going forward, because it is available since 2014, eventually I think there will be enough just numerically in terms of the sample of disputes to give a better idea of what are the conditions under which these board members are disputing, because there has to be a reason. And it probably, my guess would just be is that it's ideological. So when we get, again, more data, we'll be able to run ideal point estimation and get better idea of, are there more liberal Democrats on the board versus conservative Democrats? You know, do we see differences between Democrats that are appointed by Trump versus Democrats that are appointed by Obama, and Republicans appointed by Obama, Republicans appointed by Trump? My suspicion, again, is that there are differences, but they're not really accounted for here.
Does one of the board members do some sort of write-up, or how does it work writing up the decision?
So it's the same as an appellate court. So you get the physical decision. I don't know if it's like clerks, just like the
kind of
courts.
one member who takes the lead on writing that up, or?
That, yeah, because there can be opinions written by one board member that are just signed onto by a majority of the board, or they can even do the board equivalent of like a per curiam opinion too, where it's unsigned. But most of them are, you know, members 1 and 2 in the majority, and then member 3 dissenting.
Okay. It seems interesting since there's so few dissents to know how that,
right.
You know, who does that work of writing up the opinion.
What does it mean exactly? What is your dependent variable look like? What proportion are pro-management votes?
The dependent variable, it's about 20% pro-management votes. So because it's a time period where the majority of the board was Obama appointees the whole time, or Democrats on the board the whole time.
So 20% of the way you've constructed a dependent variable are ones.
At the member level, right? So I think that the amount of actual outcomes would be even higher. So to just, we can get fully to the Q&A in a second, but to present the results, what we see is at least cautious confirmation of the hypothesis having to do with competitive punishment, which suggests that the greater a member on the board is invested in an economic sector, which has a firm subject to a dispute, the less likely that that member will vote for the management disputant. And this holds even when the independent variable is constructed not as a raw dollar amount held in the sector, but as a proportion of the member's total holdings in the sector. And it also holds when controlling for these established factors that bear on administrative decision-making, such as the party of the member, him or herself, and the underlying ALJ decision. And then there's no discernible association between the total wealth, even though it's controlled for here.
Just two things. One, just a suggestion. I think it would be, since you're going to be presenting this and so forth, I think the institution is interesting here. It would be useful to have some descriptive information, like Ted was asking. You know, you said it, and it's very interesting that there aren't many dissenting cases, that there's 20% for men. I would put all that up there, just a suggestion. So on this one, you've got, on your key variable of interest, you've got, what, 10% significant of one-tailed test? Is that what it is?
A two-tailed test. So that one there's a two-tailed test for the independent variable.
One-tailed test, for all except personal financial interest. I mean, how robust is that if you start playing around with specifications and forms and subsamples? Does it give it?
I would say robust to the extent that I can manipulate it. Right? Yeah. So I'm happy to sort of send you the descriptive summary of the data too, which it really should be in here at this point also. But so the sorts of things that it's robust to, including in terms of limitations, both on the dependent and the independent variable, are limiting the sample to these unfair labor practice cases rather than both the unfair labor practice and the election cases. It's robust to specifying the independent variable as a proportion rather than as a raw dollar amount. And it's robust to specifying the level of personal financial interest either at the maximum or the minimum value because of these ranges in valuation that we have. I mean, that was probably not surprising because they're all linearly related. But James.
Have you looked at fixed effects for the legislators?
I haven't yet. For at the member level, yeah.
Or
That's
it's a
what I'm
year, or years.
Right. I did, yeah. So it is robust inclusion of year fixed effects. I try.
These don't have year fixed? Well, it's
This table doesn't, but it's more or less the same.
So these are member votes.
Is this a linear
Is
regression?
the unit of analysis. Do you cluster by decisions, or what do you do, like with the standard errors with respect to that?
So it does have robust standard errors clustered at the, I think at the term level. So when there's people going on and off the board. So it's the only way to sort of code the term or the regime is to look at when are people going on or off the board. And so there are some people retiring, other people coming on, and there can be like a month gap between those. So I think the time period here includes 6 kind of discrete constellations of members on the board itself. And that's the lever that's clustered on.
So I would include, instead of the pseudo-R squared, I'd go with like percent correctly predicted.
Right, I think I had the chi-squared in another version of the thing that I forgot to change out.
So a model that predicts that all votes are pro-labor gets 80% right, right? So I want to know how much your model is improving on that. You don't have much to work with.
Right.
Right.
That's true.
Perfect. I like that idea. I would take it one step further. Do a model that's all labor, then do one that's just labor and party. Then see if there's anything left after that, how much is left.
Yeah,
Because that would
that's
give you
fair.
the idea of the quantitative.
Right.
But how do I interpret this magnitude? So what is minus 0, or is that coming up?
That is coming up. You anticipated it, right? So what we see here.
What was the model?
Oh, it's a logit model, yeah, so estimated logit regression. So you can see sort of, the percentage decrease in likelihood of a pro-management vote based on the level of investment, and just because it's not necessarily intuitive here. Moving from $0 in any given sector at the dispute level to the $250,000 level and then to the $1 million level decreases the probability of a pro-management vote from around 20% to around 15%, but then there's still overlapping confidence. It's a little hard to see, but and then non-overlapping confidence bars at the $1 million level in the sector, which is about 2 standard deviations above the mean value of the independent variable personal financial interest here.
This is also a suggestion. You might have done this in the next slide, I don't know. So there's 2 other things you probably should do. You should check to see the fraction of cases that it swings the probability from above 50 to below 50%, and vice versa. And then also, that's at the individual level, but you should check at the vote level if it changes anything from a minority to majority coalition or majority to minority coalition.
Can you get Monica scores for these guys?
I haven't found them yet, but I think that it's something that
Which
His database is public.
yeah. So the Monica's base creates measures of ideology based upon campaign contributions.
yeah, it's worth considering because right now we have only kind of intuitive evidence of whether some of the board members are more kind of pro-labor or not. I mean, in large part, it's a predictable story in what the outcomes are because most of the people that are considered the kind of institutional Democrats on the board are people that have been labor attorneys their whole lives, and then most of the people that are kind of institutional Republicans on the board are people that have been either in management or working at Jones Day on behalf of firms and things like that. But it would give at least a little bit idea of what the variation is among the members and within the party too, which is I think kind of the logical next step of the analysis is thinking about what else is going on behind the scenes that either makes some of the members likely to exhibit the sort of strategy that we see here or not. Because in terms of, yeah.
No, keep going.
Okay. I was going to finish then, so.
Well, if you go back to, so why did you decide $250,000 is the middle, is the midpoint? Like, what was the reasoning between like the $1 million in the sector versus, and the 0 makes sense, or sort of, but then like, what's the mid?
It was around the mean.
It is the mean?
Yeah. Not exactly, but I picked a round dollar amount that was close to the mean.
Well, it's interesting because at the beginning of your talk, you talk about the super wealthy, and that's when we're concerned in terms of these like really, really, you know, the 1%ers or something along those lines. And so I was just wondering, if you have $250,000 versus $1 million in a particular sector, are you all in the 1%? Are
Right.
you
is there some kind of threshold level over which these sorts of things get triggered? And it may be something that the contours of it become a little bit more clear with the addition of more data and analysis too. But at least, at this stage, there does seem to be relatively persuasive evidence that something is going on. But as time marches on, there are only more people on there. And I think that now we're seeing, like, if there is a time when being super rich is going to differentiate someone from being only an average level of rich, that this would be the time to sort of thinking about it.
But let me make sure I understand that. This is saying if I go from having no financial interest to $250,000, which is the mean, that I can't distinguish, those bars overlap.
Right.
I can't say anything there. It's only in the one, when I get to 1 million, which is hardly going to be anybody's, is right? There's no
It's
mistake
2
there.
standard deviations of the mean. I don't know the actual exact percentage.
I mean, it's a put that distribution.
Right. Yeah, so what we see is even among, and I'll wrap up in a second, even among this part of the federal government that we have pretty strong priors about in terms of the professionalization of the decisions and the notion of bureaucratic neutrality that's informing them, we're seeing some sort of association between their private financial interests and their decision making in these industrial relations disputes. So it seems that personal finances and investments among members of the administration and the bureaucracy are driving their decision making, not just in ways that are kind of feathering their own nest and aren't associated with their institutional capacity or with their decision making in broad questions of public policy, but they're actually making choices that are their job, the reason that they're put in this position, that are driven in some sense, at least in part, by the extent to which they have a personal stake in the outcome, as based on their own reported personal investments. So in terms of future work, I'm going to consider the different types of remedies that are available before the board. So the board can either issue an injunction to keep a management or a firm from doing something with its employees with respect to their organization rights. They can also impose fines, and it may be that the variation among the remedies that are offered is somehow differential, and that the board members, the fines are usually not very big, just sort of give away the ending there. So it may not be that they're putting a really big price tag on, but it may be that the operational costs that are imposed on them because of injunctions or injunctive relief that's offered to the labor employees is actually kind of a greater fang in terms of the threat that it poses than the actual fines themselves. And also to look at variation in design across the bureaucracy and how certain types of organization and organizational characteristics might either enable or constrain the sort of behavior that we see in the evidence that I presented here from the Labor Board in other sorts of regulatory and adjudicative environments. So, thank you so much for your attention, and I appreciate all the questions and interest.